Good afternoon, everyone, and thank you for joining us. Earlier today, our government introduced an act respecting countering foreign interference, a bill which would give Canada new, modern tools to combat foreign interference. Canada is a strong, open, and free democracy. These strengths, however, can make Canada a target for those who wish to advance their interests to the detriment of our own. To achieve their aims, foreign states may recruit, witting or unwittingly, individuals to assist them on Canadian soil. They may also attempt to silence dissidents and promote narratives that are favorable to their country in a clandestine manner. Such actions constitute foreign interference. It is a deliberate attempt to disrupt the fundamental values and freedoms that, as Canadians, we cherish and that are at the very heart of our free and open society. Malgré le fait que la menace posée par l'ingérence étrangère n'est pas nouvelle, elle a pris de l'ampleur et s'est sophistiquée au cours des dernières années. Aujourd'hui, l'ingérence étrangère est une des plus grandes menaces qui pèsent sur notre souveraineté, notre prospérité économique et notre mode de vie. Grâce aux efforts extraordinaires du SCRS et de la GRC, le Canada est toujours en mesure de combattre cette menace. Mais dans un monde de plus en plus numérique, la nature de la menace a évolué. With an act respecting countering foreign interference, we're taking action to adapt and to respond to a world where life and consequently threats are increasingly moving to the online realm. First, this legislation would create a foreign influence transparency registry. Under this registry, all individuals or entities who enter an arrangement with a foreign government or entity and who undertake activities to influence a government or the political process in Canada would be required to publicly register these activities. This registry would be overseen by an independent Foreign Influence Transparency Commissioner who would be responsible to administer the Act and to promote compliance with the Act as well. Tout au long de nos consultations, les individus et les organisations qui nous ont communiqué qu'un mécanisme de transparence serait un outil indispensable pour contrer l'ingérence étrangère. Il est également devenu clair qu'un registre devrait être accompagné de d'autres initiatives. En conséquence, nous proposons également d'amender 4 lois fondamentales. La loi sur le Service canadien du renseignement de sécurité, le Code criminel, la loi sur la sécurité de l'information et la loi sur la preuve au Canada. Ces modifications à la loi sur le SCRS doteraient le service de meilleurs outils pour lutter contre l'ingérence étrangère et protéger nos communautés. La loi sur le SCRS a été promulguée en 1984, à une époque où l'usage répandu des technologies numériques n'aurait pas été même envisagé. Today, digital technologies are a part of every aspect of our lives, and this new context calls for CSIS to be more agile in how it can conduct its investigations. This is precisely what this legislation would achieve. Crucially, it would also enable CSIS to share information with key partners outside the Government of Canada. This information would help our partners, provinces and territories, universities, and private companies build resiliency to foreign interference. This element has been called for by business organizations and provincial leaders alike for some time now. A resilient and informed population is our best defense against foreign interference. We'll keep taking action as a government to protect Canadians from those who would try to work against our national interest. And to further expand on these changes, I will now turn to my colleague, the Minister of Justice and Attorney General of Canada, Arif Virani. Arif, à toi.
Merci.
Pardon.
Hello, bonjour. Merci, Dominic. Thank you very much for that, and thank you to all of my colleagues. This is certainly a governmental initiative that a lot of people are interested in. I wanted to address some of the justice-specific pieces of this package. This legislation makes three important changes in the area of our justice system. First, it makes amendments to the Security of Information Act. It also modernizes the sabotage offense in the Criminal Code. And finally, it introduces a mechanism in the Canada Evidence Act for the protection and use of sensitive information in the review of federal administrative decisions in the federal court and the Federal Court of Appeal. So looking at these in a bit of detail, on the Security of Information Act, that is a key tool to allow law enforcement to investigate and lay criminal charges related to conduct that may be harmful to Canada. This includes activities involving foreign influence threats or violence. The bill makes several key amendments to this legislation. It creates new offenses to better address foreign interference risks to Canada and to ensure that covert hostile activities are fully addressed by the criminal law. For example, this could include someone who knowingly facilitates the entry into Canada of agents of a foreign entity who are posing as merely tourists. It enhances our ability to address transnational threats or violence by foreign governments and those who work on their behalf, who attempt to intimidate people living in Canada and their families abroad, a very key facet. It also expands the preparatory acts offense. Here we are talking about anything done in the preparation of the commission of an offense. Espionage, for example. The amendments cover preparatory acts for both existing and new offenses, as well as enhance the existing penalties. Other changes to the Act would address the inappropriate sharing of military knowledge and amend the definitions of persons who are permanently bound to secrecy to include units within the Canadian Armed Forces. Passons maintenant au Code criminel. Nous proposons des modifications pour moderniser nos lois et faire face aux menaces nouvelles et en évolution d'ingérence étrangère. Le projet de loi vise à préciser les catégories d'infrastructures essentielles protégées, y compris les systèmes d'infrastructures privées et publiques nécessaires au transport et aux communications ou la prestation des services de santé et l'approvisionnement alimentaire. Dominic vient de mentionner le fait qu'un des projets de loi n'était pas changé depuis les années 80. En termes de sabotage et en termes de cet aspect-là, les changements datent des années de 1950. Donc, c'est là et maintenant le temps de moderniser nos propres lois. Prendre en compte, dans le cadre de l'infraction, les protections de la Charte relative à la liberté d'expression et à la liberté de réunion pacifique. Donc, les deux sont précisés dans le propre projet de loi. Créer une nouvelle infraction ciblant la possession de la vente d'un dispositif en vue de commettre un acte de sabotage. Parmi ces appareils figurent les bots, des dispositifs connectés à l'Internet, dont certaines sont infectées par des logiciels malveillants. Finally, the bill also improves how sensitive national security information is protected and used in federal administrative proceedings in the federal court and the Federal Court of Appeal. This includes creating a new process under the Canada Evidence Act. This will provide a mechanism for the federal court or the Federal Court of Appeal to consider and protect sensitive national security information when conducting reviews of governmental decisions. This new process would apply when such sensitive information is part of the legal record. The bill also amends Section 37 and Section 38 of the Canada Evidence Act. These amendments provide that, absent exceptional circumstances, any decision not to disclose specified public interest or national security information should only be reviewable by a court after the conclusion of the criminal trial and only in the event of a conviction. In other words, as part of an appeal by an accused after the conviction. This proposal seeks to address concerns about trial delay and trial interruption It would also address issues related to court efficiency and court resources by ensuring that appeals are not launched by defendants unless there is actually a conviction. Finally, there are measures directed at ensuring that national security considerations would be expressly included in the list of reasons for a judge to consider when deciding whether to issue a sealing order in relation to a criminal code warrant. Together, these pieces will better safeguard the integrity and security of our institutions and our democracy, and will better protect people in Canada from the threats posed by foreign states and those who act on their behalf. This is being done in a way that respects charter-protected rights and freedoms such as freedom of expression and peaceful assembly. We are not doing this in a vacuum. We are following our allies like Australia and the United Kingdom, who have recently amended and strengthened their own foreign interference laws to deal with the threats that we all face today. This bill is also informed by what we've learned during public consultations over the last several months. The Department of Justice engaged with provincial, territorial, and Indigenous partners, academia, the legal community, and diverse communities and diaspora communities right across the country. We've heard broad agreement that we must take action against the growing threat of foreign interference in our country. This bill is the product of that input. It is a measured but robust approach to protect our national security, our way of life, democratic values, and our sovereignty. Thank you very much. Merci beaucoup. We are open for your questions.
Monsieur LeBlanc, pourquoi insister sur le fait que le registre n'est pas une liste noire? On a mis l'accent là-dessus aujourd'hui, par exemple, dans le briefing technique. Pourquoi est-ce que ce nouveau registre n'est pas une liste noire, d'après vous?
Ça s'encadre, comme Arif a bien dit, dans le travail des alliés du Canada. Il y a d'autres exemples de registres au Canada qui existent, que ce soit en termes de lobbying ou d'autres. C'est une façon d'augmenter la transparence. On a entendu depuis longtemps, surtout des communautés diaspora qui nous ont dit qu'ils voulaient plus de transparence en qui représente un gouvernement étranger. Moi, je ne pense pas que si les gens sont fidèles à leurs obligations juridiques d'une façon transparente, c'est nécessairement une liste noire. Moi, je pense que c'est un outil parmi d'autres. Ce n'est pas une solution complète, mais c'est un outil, je pense, important à décourager des conduites clandestines qui ont, dans le passé, donné naissance à cette ingérence étrangère-là.
On the timing of the bill, what parts of this bill will actually be in place before the next election campaign scheduled? I know it could change, but if it's scheduled for September 2025, October 2025, what parts will actually be in place?
We would hope that all of this legislation will be in place. We don't intend to procedurally delay our own legislation. We intend to work with opposition parties. We intend to work with opposition parties. We recognize that in an ideal circumstance, this legislation would be in place expeditiously. But we're in a minority parliament. We're going to work with opposition parties. I'm hoping that the effort around this legislation, the opposition parties have been calling for many months for a foreign influence transparency registry. Our hope is they'll work with us so we can put it in place, but we want Parliament to be able to do its work. But we intend to proceed quickly.
It sets out a year for royal assent. So if it's a year after royal assent, for example, to create the registry, how would that be in place? It would have to be passed next month in order for the, royal assent, Senate and the House would have to pass it next month for the registry to even have a chance at being in place.
So again, the legislation was introduced 2 hours ago. We will be working expeditiously with opposition parties and our colleagues in the Senate. I'm not pessimistic that we can't build a consensus around the importance of having this legislation in place as quickly as possible. And our objective will be to work collaboratively with opposition parties and our colleagues in the Senate to do exactly that.
During the public inquiry, your government repeatedly said that intelligence is not evidence. So with the creation of these new offenses, how are you going to be able to make sure that charges are laid and people are actually brought to accountability when intelligence is not evidence, as you say?
Well, the intelligence to evidence continuum is a bit of a legal nicety, but it's really, really critical to understand. So when authorities, law enforcement authorities are gathering material, they're gathering intelligence. It transfers into an evidentiary realm when it is used in a proceeding, whether that's an administrative proceeding or in a criminal proceeding. What we're doing with this kind of measure is we are ensuring that we're providing the ability to have this discussion taking place, but ensuring also that there are safeguards in place. So this is a bit specific, but I'll walk you through part of it. There are contexts in an administrative sense, for example, where you might have national security information that relates to someone's immigration status or whether they have the ability to maintain status in this country under the Immigration and Refugee Protection Act. What we're saying is that sometimes when you need to use that intelligence as evidence in those types of proceedings, you need to make sure you have certain safeguards in place. And we're ensuring those safeguards through the use and permitting this idea about a special counsel who would be there in those sensitive hearings, safeguarding the interests of people that are not permitted to be in the room because they don't have the adequate security clearance. So it's important that we address this issue. It's important that we always uphold the protections that are in our Constitution with respect to individuals that are implicated in our court system.
Exemption, could that apply to something like the ambassador?
Juste en français.
Oui. Est-ce qu'avec les nouveaux pouvoirs que vous donnez au SCRS, est-ce que vous essayez de trouver des façons justement de transférer plus de renseignements en preuve? Est-ce que c'est un début?
C'est pas une question de transférer plus d'informations parce qu'on a toujours des safeguards, les guardrails comme tels, les protections, effectivement, merci. Les protections qui sont déjà dans la loi criminelle, dans notre propre Constitution. Il y a toujours un aspect où il faut avoir l'approbation d'un juge, par exemple, pour chercher une warrant comme tel. Mais avec ce qu'on a ajouté dans ce propre projet de loi maintenant, on a renforcé les propres protections qu'on a déjà, mais aussi on a ajouté quelques-unes des protections. Par exemple, j'ai mentionné le crime de sabotage. C'est tout à fait évident avec les manifestations devant une chose comme un édifice, par exemple. Vous pouvez une situation où les personnes sont visées, mais ils sont en train de juste exprimer leur propre expression qui est protégée dans la charte. Donc, on a précisé directement dans le texte de ce projet de loi que votre droit sur...
Est-ce que vous voulez transférer plus de renseignements en preuve? Est-ce que c'est le but?
Le but, c'est de toujours sauvegarder une situation où, dans le contexte où il y a une transférence de l'information, qu'il y a des safeguards et les protections qui sont là pour protéger les Canadiens sous la charte et sous notre système criminel et droit administratif. Et c'est ça qu'on a fait.
MPs will now directly be told the information. Will CSIS now have the power to directly tell MPs if they've been hacked or if they are the subjects of foreign interference in any way? That was obviously one of the main topics of conversation leading up to this. So can CSIS, CSE, other security intelligence agencies directly transmit that information, or does it still rely on you as minister to sign off on it?
No, I don't have to sign off on CSIS providing threat reduction briefings or general security briefings to parliamentarians. What we do is work with the administration of the House of Commons, the Speaker, the Board of Internal Economy, and the Sergeant-at-Arms, because in the context of Parliament, it's not a government institution. I think you might have some of my opposition colleagues surprised that CSIS was engaging directly with parliamentarians. The most appropriate way is for CSIS to pass the information on to parliamentary authorities and then ensure that they're able to brief the MPs, which is exactly what was done in, I think, the case you're referring to. In my conversations with the director of CSIS, from time to time he informs me that they will be reaching out to a particular parliamentarian to discuss perhaps a context where they may want to increase their own security measures. This is always done in partnership with the House of Commons as well.
You will have to sign off on specific disclosures so that CSIS can do more high-level preventative briefings with other institutions outside of the government, but that the minister responsible would still have to sign off on personal information disclosure. So, for example, if an employee at a bank was maybe being paid off by a foreign entity. Is that correct? Can you just explain that a bit more and how that would relate, for example, to an MP?
Somebody frauding at a bank relating to an MP?
That was one of the examples at a technical briefing, that the minister still has to give the sign-off on particular details being released by CSIS. Can you confirm that's the case, and in which cases that applies?
So obviously the legislation was introduced today, so I would not have had any experience with the director of CSIS under the new legislation of how.
You presented this bill, so you know how it works.
What I'm telling you is the advice on what information is properly protected comes from the director of CSIS. I have always followed his advice in terms of how a particular piece of personal information should be protected. I rely on their advice, and if Parliament adopts the new legislation, I would continue to be governed by the advice of security professionals in terms of what's the appropriate disclosure. What I do say to the director of CSIS often, and this goes back to my predecessor at Public Safety, about the importance of informing parliamentarians in terms of the general threat landscape, and when CSIS has information about more specific threats, it's important for them to work with the House of Commons, or in the case of the Senate administration, to ensure that the appropriate information is passed on in the appropriate way.
Under the protest exemption in this bill, would that apply to something like the Ambassador Bridge protest that we saw during the convoy protests?
Well, it's always going to be case specific in terms of the assessment that's made. So what we're doing is we're modernizing the sabotage provisions that haven't been modernized since either 1951 or 1952. These are talking about naval vessels, et cetera. We're talking about things such as attacks on hospitals, attacks on bridges, et cetera. So that's important. But secondly, it's also important that we uphold what wasn't in place in 1952, which is the Charter, right? Section 2B entrenches your rights to lawful expression and freedom of speech and peaceful assembly. That's critical for Canadians at all times, especially now. So what we're saying is by specifying that is that it's going to always be calibrated. Another safeguard that's in place is that in order to proceed with what can be a sensitive issue that relates to people's constitutional rights, you can't proceed with the prosecution without getting the consent of the Attorney General that's applicable. So it may be in the case of the Ambassador Bridge for the consent of the Provincial Attorney General in Ontario. If it related to national infrastructure, it might come across my desk. But by building in those safeguards, what we're ensuring is that we've heard Canadians, we consulted with those Canadians. They said, yes, we need more protections from foreign interference. We need more protections vis-a-vis our critical infrastructure. But at the same time, we want to be able to express our views, including our very important views on political issues, which is often what's being.
All blockades on international bridges?
It very much depends on the context, right? You can't answer that in isolation. It would depend on what is transpiring in a given situation. But what I can say to you is that when you have things such as a ransomware attack on things like I believe it was Newfoundland's healthcare system that's crippling a hospital and particular institutions, and if it's being orchestrated by a foreign entity, we are targeting that. We are responding to that as we should to make sure our laws are supple enough to deal with the challenges of today, not the challenges of 1952.
Merci beaucoup.
Are all these offenses criminal? Can you just confirm if they're all criminal offenses?